Hi, it's Mike DelSignore, Massachusetts OUI lawyer, and I handle a lot of cases out of Stoughton District Court. My office is in Stoughton. It's one of the courts I've attended most frequently throughout the years of my practice. And I want to talk about a case and what some of the keys to success for obtaining a not guilty verdict for a client of mine in a recent trial. One of the things that I do when I have an OUI charge is I look to see everything my client did right, everything that I can say is inconsistent with somebody being under the influence of alcohol. So in this case, my client was caught by a state trooper who's on 24, alleged to be driving erratically, crossing the marked lanes. There was no accident, which is helpful and allowed me to diminish the driving. So what I was able to do is say that although the officer maybe had a reason to stop him for a minor traffic infraction, my client pulled over safely and immediately. He had his headlights on. He was obeying the speed limit and merely crossed the marked lanes into the breakdown lane a couple times. You might see that in your report referenced as the fog line. But the argument was that even though there was a basis for the stop, that this wasn't some outrageous erratic driving. He wasn't speeding, wasn't all over the road, didn't cause an accident. So I was able to minimize the driving. Then when the officer approached the window, spoke to my client provided his license registration without any difficulty. So he cooperated with the officer. He spoke to the officer, told him how much he had to drink. There's an admission of some drinking. He said he had 2 to 3 beers, but didn't give a time period. He was ordered out of the car and asked to do some field sobriety tests. Now, this is very common in OUI cases. And when my client got out of the car to do these field sobriety tests, he got out and didn't lean on the car or use it for balance. So some of the things they look for when they pull somebody over is, does the person lean on the car or use it for balance? How do they provide the license and registration? Are they able to provide it immediately and without any difficulty? And my client was able to do these things all without any issue. So these are signs that someone is not impaired. So when police officers make arrests, they have a training manual and they're kind of looking to check things off. They want to see, how did you pull over? When you got out of the car, did you lean on it, use it for balance? And were you able to answer basic questions? Did you provide your license and registration, or did you fumble it? So what I do is I point out everything my client does right. I basically suggest that if he was under the influence of alcohol, he wouldn't have done all those things right. It's inconsistent with somebody being impaired. Then the officer does the field sobriety test. And on these field tests, they're looking for a lot of little things. They're looking for, do you use your arms for balance? Do you take the correct number of steps? Do you maintain heel to toe? So it's not just one thing. So a lot of times you'll see in a report that somebody missed heel to toe. But there's more than just missing heel to toe. There's the correct number of steps. Did you stop while walking? And heel to toe misses are not just there has to be a half-inch gap. So if you see in the report missed heel to toe, the officer may have thought, and a lot of officers think that you literally have to bang your feet together to connect heel to toe. But their training teaches them otherwise. It tells them, no, there can be a space. On the one-leg stand, a lot of times you'll see client put his foot down after 4 or 5 seconds, or maybe 15 seconds, or whatever the time limit is. But a lot of these reports, there's no mention of, did you lift your foot back up? So, a lot of officers will say, yeah, you put it back up and continue to 30, because these reports are made immediately after the incident. So if something is not in the report, by the time these cases go to trial, a lot of officers will say, it must not have been there if I didn't mention my report. So when you're charged with OUI in Stoughton, what I do is I'll try to list out all the things you did right. And my argument to the judge will be, and I've done a lot of these cases, that, this is inconsistent with somebody impaired. You wouldn't have done all these things right. You wouldn't have acted this way had you been under the influence of alcohol. And so that strategy works a lot of times. It doesn't always. If there's a breath test, we'll have to exclude the breath test or deal with that. If let's say you did a lot of things wrong, we may need to put you up on the stand to testify, to explain, to sort of rebut this. But that's a common approach to winning an OUI case, Stoughton District Court. And it's something that I would go over with you. If you call me, I'll go over your report, explain the best defenses to an OUI charge in Stoughton. I handle these all over Massachusetts. It's my passion helping people charged with drunk driving. Feel free to contact me anytime. My name's Michael DelSignore. You can call, text 781-686-5924. I'm here to help you on an OUI charge and help you avoid an OUI conviction. And that's my goal. And if I can help you do that, I'll be glad to do it.